The APM had its withdrew its what do you call it? Its appeal because according to what the judge we had, the judges said that their appeal did not have prayers for determination. Can you please give us help us understand what happened there?
Yes, APM appeal. These are some of the challenges I said. When people blame the judiciary, we should also look around. It became obvious in the Supreme Court that it is an appeal that shouldn't have been there if the council had looked at the issues properly. So the courts have a way of making you to swallow your vomit in court by asking you certain questions. Have you looked at this? In view of this that we have done, do you think we should do it again? And ultimately, a lawyer looks at it and takes what we call taking hints. You take the hint of the court that this is not the matter that should stay there. They won't say they won't be the one to say withdraw it. They will drive it to the point you say I'm withdrawing it, and then they will say, well, on the application of counsel, we strike it out. That's what happened with the APM matter. I think the issue they raised is an issue that the Supreme Court had decided before now and not long ago, and it was stressed that it shouldn't. No lawyer should be pushing such issue again. Normally, when
Doc, let's look at what transpired yesterday again, an aspect with Atiku Abubakar and Peter Obi. Well, Atiku's Abubakar's appeal against President Tinubu's election was judgment was reserved by the 7-member panel led by Milord Justice Ian Okoro, as well as Peter Obi's appeal. Please explain to us what exactly is going on when we hear that, or when they say they reserve judgment.
Yeah. I must confess that I didn't watch the entire proceeding. And today reserve judgment. I know that the issue of admission of new evidence is something that they paid attention to. But when the court said we reserve judgment, it's saying that we will give our judgment in a later day. We have heard you. We'll go and look at all your submissions and look at the facts of the case. They will tell you the date where we'll give the judgment. Now, when the court reserve judgment, it means that on that day, the court will read the entire the judgment is given and give all the reasons. But normally, in some cases, the court will just say, today we have had the appeal is dismissed, appeal is allowed, reason to be given later. In which case, the parties may go home from that place, they celebrate in the decision of the court, then later the court will come and give its reasons for it, which is more detailed. So now that the judgment is reserved, it only means that on a day they will fix. They will notify the parties and maybe the whole public to come and hear their judgment. That's what the reserve judgment means.
All right, but Doc, okay, for the Atiku case, what Chris Uche did yesterday from our reporters who were on the ground was he sought to tender the academic records of released by CSU, that's Tinubu's academic records released by this and along with the position by the registrar from CSU. That's what he sought to do. I'll just take his words. This is what he said, quote, "We're praying for an order of this honorable court seeking leave to present fresh evidence on appeal based on the depositions on oath from Chicago State University concerning the secondary respondent, Mr. Tinubu, and all that." So that was his argument, that the court should admit the fresh evidence, pointing out that there were discrepancies in the documents. But of course, the Tinubu's team, came up to ask the court not to do that, as well as INEC. I think that is what the judgment for was reserved for.
It's not the main appeal now.
Yes, that's what I believe it to be.
Okay.
Okay. So you're saying that the next hearing, when they communicate to the public or to the parties, will be to say whether they want to admit the evidence.
Yes.
Is that
on
what
that particular issue now? They reserve on that issue. They will say, look, we are admitting or we are not admitting. Then they will not give them time, or that day they will say, I argue a main appeal. So the main appeal has not been answered. It's just this preliminary issue of bringing new evidence. So I guess that's why they said they reserve the judgment, because of course, since that what decision will affect the hearing of the main appeal, it's necessary that they should give a reason, a judgment on it before the main appeal is heard.
There was this controversy. The judge, the lead judge, Justice Okoro, presented to the lead counsel for Atiku Abubakar, Chris Uche, asking whether he should go with the Constitution or with the Electoral Act. The controversy was about Mr. Chris Uche, your colleague's attempt to introduce that fresh evidence after the expiration of the 180 days statutorily provided for filing trial and determination of election petition, since this was introduced after the election petitions. So what Milord Honorable Justice Nyakoro asked Chris Uche was, why are you bringing this evidence now? Do you want the Supreme Court to brush aside constitutional provision to entertain fresh evidence? But what Chris Uche said was that the law only compels the tribunal to hear and determine an electoral dispute within 180 days. So where do you stand on this issue of Constitution versus Electoral Act with regards to this?
It will not be right for me to say where I stand. When
okay, sorry. Help me understand what is going on here. Help us understand. Yes, sorry.
Well, what happens is that on the principles of law, when you present your case, you present according to the provisions of the law governing the case. And if the law says bring all the evidence at a particular time, you do. And then if in certain cases, exceptional cases, you may have to convince the court why you bring any evidence outside that time. And then maybe during the trial, why you bring evidence outside the trial. Like in this case now, you have to convince the court why you're going to bring evidence at the stage of the Supreme Court appeal. The circumstances can be very stringent. So it is what I'm sure the lawyers will try to convince the court that they have met this qualifying circumstance in that case. I don't know. So it's the judges that will look at all the evidence, all the facts from both sides, and decide whether the circumstances justify it or not.
Okay.
And that's one of those things we are saying. Quite unfortunately, the social media has already judged. Social media is all about. Let us understand that it could be the other side. I mean, you can be supporting Atiku today, can be the other group is supporting TInubu, and they all have the same passionate commitment and expectations.
Yes, Justice Okoro stated that he had two letters from the CSU, two conflicting letters. One, which said TInubu had the correct records from the university, and another letter which is coming from Atiku Abubakar's legal team, stating that whatever it is they're appealing for or appealing with, of course we all know that they're claiming that the records are not genuine or were forged. So what happens in this case? Because the judge is asking the Atiku legal team which one he should use. So what do you say to this, sir?
Well, you see, that is actually one of the reasons why the courts are very slow to admit new evidence at the level of appeal, particularly the Supreme Court. Because, you see, when you bring one, the other person brings the other. It means you are reducing the Supreme Court to a court of trial to evaluate evidence. And that is not the work of the appellate court.
Another thing the judges told the Atiku Abubakar team, led by Chris Uche yesterday, was that they need to prove, since it's a criminal allegation they're making, they need to prove it beyond every reasonable doubt. What does this mean? What does beyond reasonable doubt or every reasonable doubt mean in this instance, sir?
Yes, you have to prove it beyond the position where all those who reason, who look at things dispassionately, will be able to say, look, we are convinced. But again, that's what I told you, that is not what you can do at the level of the Supreme Court. And that's what the Supreme Court is giving hints. This you are talking about is a matter of proof now. If you have letter A from CSU, you have letter B from CSU, and they are saying different things, then you need to convince the court which one is the proper one. You need to bring the CSU to say this one is ours or this is not. And all that is not at the level of the Supreme Court. That is just the point. So that is why it looks to me a forlorn effort that won't achieve anything. Let us say if the evidence that was taken at the tribunal is enough for them to build their appeal, they should give the appeal on it. Otherwise, they should give up because the point is that the system that we have, the contents of the laws we have, are not such that favor those who are complaining against illegalities in this country. The law is still in favor of a man who has been able to go and the end justifies the means approach. And that is the challenge we have for the election petition. So you hear a case now of somebody say, just get it, let them go to the court. But I believe that Nigerians should get interested in what happens in the law, in the content of the law. When it changes, and I hope that those who have beaten the law will also change, then maybe things will be different than what they are today.
Atiku Abubakar had come out last week to say that he's urging the court, the Supreme Court, to take his appeal on its merit and to look at it from the purview of justice, lessons of justice, not technicality. What do you think about that appeal by Atiku and what's going on?
Well, with all respect, I'm a lawyer and I love justice. But the justice that the court dispenses his justice according to law. The law operates with rules, technical rules. Otherwise, the man in the street will be doing the same thing that I am doing as a lawyer. But the Nigerian nation realized that we must have a group of people who are properly trained to know how to receive evidence according to rules and to administer it according to rules. So, while technicalities can be bad, when people exalt it beyond the doing of justice, but it cannot be said that to be bad if the law says you should file your case in 2 months, and you file it in 2 months and 2 days. You have failed. So we must, even in seeking for justice, you must obey the law. So I know that even those who are arguing that now, we are the people who are also who are champions of technicality. In the other cases, they're arguing. You don't see the way it works. Take for instance the lawyers for Atiku, Chris Uche, is one of the lawyers we know very well. That as senior advocates, they will find every hole and every technical to fight their cases. Unfortunately, they're on the wrong side now. So that is the thing. But technicalities are important, but it must not be exalted above substance. Now, the justice that is done by the court is not the justice that is done in the streets. For instance, in the street, if you shout somebody, there's a shout of ole, 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 they'll start beating. It may turn out to be the person is innocent, nobody cares. But the court will say, no, hold it first. Who saw it? What happened? And all that. And I think ultimately everybody would appreciate that is better than mob justice. So without technicalities, we'll be ending up in mob